Hi, and welcome to LawSplained Simply, a channel designed for you to educate you and to empower you when making litigation decisions. My name is Ruzbo Hosseini, and I am a partner at Cambridge LLP, a law firm in Toronto, Ontario, Canada, that on a day-to-day basis helps its clients with their litigation needs. In this episode, we will be discussing default judgments and what to do when a judgment is awarded against you in default. So let's begin. So what is a default judgment? Well, if you are a defendant and you've been served with a statement of claim in a lawsuit and you don't defend within the time limits prescribed for in the court rules, which is 20 days with certain exceptions, the plaintiff may do what's called noting you in default. And noting you in default means that you will not be able to take any further steps in the litigation because you didn't abide by the timelines for defending under the court rules. Once the plaintiff notes you in default, he or she or the company, if that's the case, may then obtain default judgment against you. And they can do that in basically one of two ways. The first is over the counter with the registrar of the court. The registrar is not a judge, but a court staff that's tasked with, in this case, awarding judgment in certain cases. So, for example, if there's a liquidated sum or a debt claim, and a liquidated damages award is an amount which is either proven, is agreed upon, or fixed prior to the lawsuit. Default judgment can be awarded by a judge or associate judge of the Ontario Superior Court for unliquidated claims. And finally, by the registrar in cases of land recovery, personal property recovery, or mortgage-related relief. A default judgment is a final and binding order unless it's set aside. So, what happens if there's a default judgment against you? Well, the court rules provide a pathway to getting a second chance for setting aside that default judgment. And in that pathway, the court is granted discretion to determine whether or not the interests of justice favor giving you that second chance. And the court, in deciding whether or not to give you a second chance, can vary the judgment, can set aside the judgment, or can impose terms. Some of those terms could be, for example, imposing a timetable or other orders that the court may deem just. And in determining whether or not to set aside the judgment, the default judgment, the court will review 5 factors. Those 5 factors are promptness, the excuse for the delay in defending, whether you have an arguable defense, whether there's any prejudice to the plaintiff, and whether granting the order setting aside the default judgment would put the administration of justice into disrepute. So the first factor is promptness, and the court will look at how quickly you brought your motion to set aside the default judgment once learning of the judgment against you. The second factor, which is the excuse, the court will look at whether or not you have a good excuse or explanation for why you didn't defend in time. The third is that the court will look to see whether you have an arguable defense, or do you just have a defense that's boilerplate or that's unlikely to succeed. And then the court will look at prejudice. And prejudice is defined as the harm, detriment, or disadvantage to a party, in this case the plaintiff, in their rights, claims, or ability to present a fair case if the order is granted. So an example of this would be, let's say several months go by before you discover the judgment. And in that intervening period, a witness dies, a key witness dies. Okay, that's a factor that a court will have to take into consideration in determining whether or not to grant the order. And finally, the court will look at whether or not there is any effect on the overall integrity of the administration of justice. And this is really a backstop. The court may decline to set aside a default judgment where doing so would bring the administration of justice into disrepute or reward egregious behavior. So, for example, let's say you receive the statement of claim, and it's very clear in the evidence that you received the statement of claim, but you just simply ignored it, and you have no good evidence to show otherwise, or the evidence clearly shows that you ignored the timelines. Well, the court's going to take that into consideration because the court doesn't want to reward behavior that tends to show that a defendant simply ignored the court rules. So what do you do when you have to bring a motion for setting aside a default judgment? Well, there are some steps that you need to take. First is retrieve all the relevant documents. Retrieve the statement of claim, the affidavit of service, the default judgment, and any enforcement records that may exist against you. If there's an ongoing enforcement actions against you, particularly by third parties through garnishments, for example, you may need to consider staying the enforcement proceedings as well. So that would be an additional motion or additional relief sought in the motion to set aside the default judgment. Then you need to prepare your materials. You need to prepare a notice of motion, the supporting affidavit that goes with the notice of motion, which is the evidence that you're going to rely on. You should always prepare a draft statement of claim to show your defense, and then put all that in a motion record, serve it, and then file an affidavit of service. Then once you have prepared your motion record, you need to serve it on everyone. You need to serve it on all the parties. And in addition, you need to prepare what's called a factum, which is a written statement of the facts and law. You should always do that for every motion, particularly this one. You'll need to attend the hearing of the motion, where a judge or associate judge will hear you and weigh the evidence and make a decision. And then the court will make its decision, either granting an order to set aside the default judgment or not. And if the court does set aside default judgment, the court may impose terms. So some key considerations to take into account. So what are the factors that favor granting relief, which is an order to set aside the default judgment? Well, is the motion brought promptly? Is there credible sworn explanations as to why there was a delay? Is there a draft defense that creates an air of reality? Was service defective or irregular in any way? And will the plaintiff suffer some sort of prejudice, which we've discussed? What weighs against making an order to set aside default judgment? Well, a long or unexplained delay, no credible explanation for that delay, bare hearsay or vague denials, a defense that lacks an air of reality, and prejudice to the plaintiff. One thing that should always be obtained or sought at least is consent, because in many cases, if you ask the plaintiff to agree to set aside the default judgment, they will do so. And that's called consent. And so if the plaintiff consents to setting aside the judgment, then there may not be any need for a hearing at all. So here are a few practice points that you should remember. Act immediately. While there are no fixed deadlines for bringing a motion to set aside a default judgment, time weighs against you. And so the faster you act, the better you look, quite frankly, and the higher the likelihood that you will succeed. Scrutinize service of the statement of claim. Because if service is defective, that in and of itself may be grounds to set aside the default judgment. But in any event, if there's any defect in service, the court will weigh that as a consideration. Swear a strong affidavit. Address all the factors that we discussed a couple slides ago to show the court that really this was an innocent mistake or an innocent error on your part. Show an arguable defense. It's not enough just to say that you were delayed for some reason that was beyond your control. You must also show that you have an arguable defense, and vague or boilerplate terms in a defense won't cut it. Seek a stay if needed. If there are enforcement actions against you, particularly by third parties, make sure that you bring that to the court's attention. And anticipate that the court may impose terms, for example, a timetable or a schedule that you will be required to follow as a condition for granting an order setting aside the default judgment. And finally, consider consent first. As we discussed, the plaintiff may agree to set aside the noting in default. And so there may not be a need to bring the motion in the first place, or at least there may not be a need to go to the hearing if the motion is brought. So always ask, because you don't know if you're going to get consent if you don't ask in the first place. Thank you very much for joining me on this latest episode of LawSplained Simply. Don't forget to like, subscribe, and comment. And don't forget to join us once a month where we discuss legal issues that may apply to you. Thank you very much. Bye-bye.